Business organizations piercing the corporate veil, breaking through the corporate limited liability shield. Forming a corporation is intended to create a veil of protection for the shareholders. However, creditors sometimes are able to break through the limited liability shield of the corporation and hold the owners personally liable for the corporation's debts. This most often occurs where the corporation lacks separation from the owners, especially where the owner and the corporation are virtually one and the same. The veil of limited liability is pierced most often where the corporation has a single shareholder. It sometimes takes place when there are two shareholders, and seldom takes place when there are three or more owners. A key factor in these piercing cases is intermingling of bank accounts and assets. If the owner treats corporate assets as his or her own, the court will do the same and hold the owner personally liable. The court is looking to see if the corporation is merely a shell. Courts will not allow corporate liability shields to be manipulated to defraud or create injustice. As well as intermingling of assets and the acts of the owner treating corporate assets as his own, some other factors are considered by the courts when deciding whether to hold the shareholders personally liable. Under-capitalization, a lack of investment in the company when compared with similar companies with similar businesses, will point toward the corporation being a sham. The board of directors and officers of a corporation hold important decision-making roles. If the board and officers are not appointed, there are no votes on significant decisions, or they're dominated by the shareholder. This factor will point toward piercing the corporate veil. Similarly, a lack of formalities, such as failure to hold board meetings and record corporate minutes, will also point toward piercing the veil. The court will look at all these factors when making a determination, but they are often found together in piercing of the veil situations. If the corporation was not properly formed, it may not exist, so is incapable of shielding the owner from liability. Perhaps the articles of incorporation were not filed effectively with the Secretary of State. Strictly speaking, the corporation in this situation doesn't exist. The creditors can claim the business was a partnership and hold the owners personally liable for the company's debts. However, errors in formation are rarely punished so harshly. A de facto corporation is held to exist, and limited liability extended to the owners if there was 1. Substantive compliance with the process of formation. The filing was almost complete. 2. The owners acted in good faith and were unaware of the defects in the filing. And 3. The business acted like a corporation, followed corporate formalities, appointing a board of directors, etc. Estoppel is another theory for barring the creditor's attempt to hold the owners of a defectively formed corporation personally liable. If the creditor contracted with the company believing it to be a corporation, the creditor is barred from later claiming it to be a partnership. The privilege of limited liability for owners is not destroyed by missing signatures, incomplete forms, or other defects in the incorporation process. Equitable subordination is a provision of the Bankruptcy Code. An owner of a corporation can invest in the company by acquiring shares or by making loans. The owner either increases her shareholding or becomes a creditor. As the owner and the corporation are separate entities under the law, there's nothing to prevent an owner becoming a creditor and treatment as a creditor in a case of liquidation. However, to avoid unfairness to other creditors, under the principle of equitable subordination, an owner-creditor's claim can be relegated to the back of the line. A debt owed by a corporation to its shareholder can be subordinated when some or all of the following factors are present. The shareholder committed fraud, illegality, or breach of fiduciary duties. The shareholder was responsible for under-capitalization of the corporation. She should have funded the company via equity, not debt. or alter ego. Corporation and the individual are essentially one and the same. It's much easier for the trustee and bankruptcy courts to subordinate the claims of an insider like a shareholder under this doctrine than it is to subordinate the claim of a supplier or arm's-length lender. Some breach of duty is required, but gross misconduct is not necessary to subordinate the debts owed by the corporation to a shareholder.